Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we're joined by Robert. So, Robert, first of all, thanks so much for taking the time and speaking with us. And perhaps maybe you could tell us a little bit more about yourself, and we can get going.
Yeah, thanks so much for having me. I've been like a long time viewer, and to see myself reflected on the Zoom screen, it's awesome. So I'm happy to be here. My name is Rob Barber. I am a licensed paralegal. I own a firm called Prevail Paralegal Services. We have three offices right now, one in Niagara Falls, one in St. Catharines, and one in Hamilton. We primarily practice in the areas of landlord tenant board and small claims court litigation. We also do a bit of regulatory professional discipline cases, and we're just starting doing peace bonds. So what are commonly called restraining orders. So yeah, we've been practicing. We're in our fourth year of practice now, and things have been going very, very well. We're pretty busy. Our firm in total has, I think, five licensees, and yeah, we're growing, and it's been great to kind of fill the gap between self-represented litigants before the justice system in whatever capacity it is, whether it's before a tribunal, whether it's before a court, and then filling the gap between them and then having to pay for a lawyer. So we have this beautiful little profession carved out, and we're happy to competently provide those services to the public.
Yeah, that's really interesting. In 4 years, you've seen that growth, and maybe you could talk kind of how that you've noticed, from 2018, 2019 to now, and how kind of you've evolved there with bringing on licensees, and anything you could share for any newly licensed. I know a number of students are writing or just finished writing their exams today, and while they're mulling over, hopefully I passed. The next step might be, well, what am I going to do 6 to 8 weeks from now if I get that letter from the law society or the email that, hey, you've passed the exam, and then they're wondering what's next. So any insight you can share about starting your practice? I mean, I don't know if you were doing anything beforehand before running Prevail, and anything you could share with anyone listening.
Yeah, so I mean, I guess the best thing that I can share is that nothing that is worth doing is going to be easy. So yeah, like it's been hard. Like it's always hard. It's always a grind. But if you have the personality where you like that, like you thrive in challenging environments, and you're looking for like meaningful, rewarding work. If you're a workaholic like I am, then it's the path. Like I would recommend highly starting your own firm. So I started my firm almost right out of school. I went to paralegal college at Mohawk. I graduated, and during my student placement, I was at a traffic ticket defense firm called Street Justice under a paralegal called Eric Madison. Eric was fantastic. Eric's a mentor. He still is a mentor. I took advantage of having him around to really learn the ins and outs of running a firm. Like having like there, so like different firms operate in different ways, but there are some consistent lessons that you can learn to running a practice, like everything from client management, case files, like like really advancing a file through the intake to the disposition. So there's a lot of similarities, and I really focused on how Eric ran his practice, and so after my student placement, I was working there as a legal assistant as I did my licensing process and my exam, and then after I got my license, I just started my own. I just registered a business name, and I got business cards. And so once you spend like $20 on business cards, you're pretty much are pot committed. You can't just go back from that point. So it's one of those things. Like I remember in our practice management class at Mohawk doing a business plan for like a paralegal firm, and you could sit there and split hairs forever, just like trying to figure out every single source of revenue and every single expense and operating cost you'd have. But at the end of the day, you could run into analysis paralysis, and sometimes it's good just to pull the trigger and get things done. So that's what I did. I registered business name. I like drew up this like little logo on my phone, and then I got those business cards, and I was like, that's it. Like now I'm a paralegal. I've got my firm and I've got to make it work. So my back is up against the wall. I got bills to pay, and then I rented a little office. I started in Thorold. It was the cheapest rent in all of the Niagara region, and then that's where I started. It was like this really small. I think it was 75 square feet. So I had like a small desk and then my little chair and then a chair across from me for clients, and then the case files would just go in the side drawer of the desk, and I had some pens, and you know what, when that was my investment, and then I look at where we've gotten today. Like we've got 3 offices, and we've got like this fantastic team that we have who just come to work every day with their game face on, and we're just kicking butt, and it's been great. But you know what, it's been a grind, and I wouldn't have done it any other way. It's been awesome. So yeah.
Yeah, congratulations. I know certainly, the firm's getting success in the community and beyond there as well. And I guess you mentioned these 3 areas, and let's maybe start with the landlord tenant board. I know recently, I think yesterday someone was telling me, there's this hey, we've hired a bunch of people, and don't worry, your matters are going to move along faster. We got all these vacancies we're still looking to fill. And maybe you could tell us kind of a bit about your landlord tenant practice, because there's a lot of interest. I mean, there's every day I see a new article. There's like a rent strike in this
Yeah.
building, and
Yeah.
delays in the landlords that are struggling, right, with mortgage and things like that. So what kind of is your focus? Is it sort of split between the landlord tenant side, and what are the kinds of applications you're dealing with?
Yeah. So our firm represents both landlords and tenants, and we wouldn't have that any other way. Just because when you hear different perspectives and you're dealing with different parties on each side every day, you get that like, what is their counter argument going to be? Like you can kind of predict things based on your own representation of people in the opposing parties situation. So yeah, we represent both sides. Our most common applications are probably rent arrears. um, those are pretty common before the landlord tenant board. We do get conduct issues like serious fire hazard, um, violence between tenants, those kind of like conduct related issues. And then another big one we get are owner occupation or purchaser occupation. So a no fault eviction, the tenant hasn't done anything wrong, but either the owner or one of the immediate members of their family are looking to move in and occupy the unit themselves, or they've sold the property and the purchaser intends to move in themselves. So those are probably the most common cases we deal with in both sides. So defending against those, or pushing those through the board. You mentioned the landlord tenant board and what they've been doing for backlogs and delays. So right now, I'd probably estimate between maybe like 7, 8, 9 months from the time that you file an application with landlord tenant board till you get your hearing. But they've been, I can't, like, they've done okay in terms of pulling up their socks from COVID. Like it used to be probably 13 months. Like there were some files I had where it was like 13 months during COVID, and the whole time you have these people who are not paying rent. So the landlord comes to you. Maybe they tried to negotiate with the tenants themselves for 2 months. Maybe they issued an N4 form and it was fatally flawed, or they did it wrong. And then they come to you and you have to start that process again. And then they're waiting in line for, it's horrible. Imagine too, like, and we're not talking about like the monopoly man and having a whole bunch of properties. We're talking about like people with their second homes, and they're still paying a mortgage, and they're now having to pay double the cost of a mortgage to just float that property. And then they're also having the same maintenance obligations that they had before. So a pipe breaks, they're not getting rent. They haven't had rent for however long, and now they have to go and fix a pipe in the unit. It's a horrible situation. So and the media has been doing their part, especially recently. Like they've been really highlighting some of the horror stories that people have waiting all this time to get to the board. But I've noticed that. Let me tell you a couple of things that I think the landlord tenant board has done, and they're moving in the right direction, although it's not perfect. They are, for one thing, if you do a rent arrears application, so if you're doing an L1 application to try and recover rent arrears, then they have something called a self-scheduling option. So within a few days of filing your application, you'll get a notification that you can go and pick your hearing schedule. And I believe it's all automated. So I think what happens there is they end up filling in gaps for canceled or withdrawn hearings. And so that sometimes you can get a better turnaround time, and at least you know when your hearing is going to be, so you can kind of prepare for it. You get that deadline. Maybe your negotiations with the tenant get a little bit like they can progress a little bit better because you know that there's going to be this inevitable hearing coming up and it's looming, and it kind of gives you that incentive to negotiate a bit more. Other things that the landlord tenant board have done. So there's the double-edged sword. So we've been able to get shortened hearing times, and during COVID, sometimes we would wait like a shortened hearing. So say there's a conduct issue with a tenant, like we had ones where there was active fire problems. They would have like a propane tank inside of the unit, and it would be a fire problem. No fire detector, smoke detectors. They won't let the landlord in to fix it. And so you'd have all of these conduct issues. You'd request a shortened hearing, and they'd be like, "Yeah, that's grounds for shortened hearing, but we're not going to give you a hearing date until 6 months." And technically, that's half of the time of you were waiting for your hearing anyway. So 6 months, that's a long time. Now they've gone a little bit better. You're getting your hearing within, like, I think we had one the other day. It was a month. So they expedited it, 30-day wait. But the problem was we needed witnesses, and so we submitted our requests for summonses to summons these uncooperative witnesses. And while they expedited the hearing, we ended up having problems getting those summonses to witnesses, all of the ancillary or cursory things that are part of bringing your application to the landlord tenant board. So, and we were sending emails every day, like, "Hey, we've got the shortened hearing. It's coming up. We need these summonses issued so that we can get these witnesses to actually come to the hearing." So they eventually got it. We were on like 5 days before the hearing. We ended up getting our summonses issued, and we had to go and serve them like right off the bat. I literally got in my car out of the office and drove one of these summonses to a witness's home. And but like they did a good thing. They got the shortened request to shorten hearing. They fixed that, but then they're still having delays in other areas. So until there's kind of that collaboration between all of the working parts, it's, like little pieces here and there. It's pretty flawed. It's pretty hard time to be a landlord in Ontario. And same for tenants. I mean, like if you're having a problem where like you've got mold in your house and you're sitting there breathing in like black mold and your landlord isn't acting, and you can't twist their arm to get it done, you're waiting for a landlord tenant board hearing. And if that's like 6 months down the road, you're waiting all this time breathing in like mold spores or whatever other maintenance issues you might be dealing with. So yeah, they're trying. They're trying. You could see that they're like the wheels are turning. They're hiring adjudicators, but there's definitely a lot of flaws. Another issue too. So one thing that they did with landlord tenant board decisions is they very seldom will give a decision from the bench. They'll usually conclude the hearing, parties will go away, and then it's supposed to be within 30 days. Sometimes it's up to like 2 or 3 months away. You'll get a hearing emailed to you. So there's an issue with you get a lot of observers watching these landlord tenant board hearings, but if the decision that's based on what you've observed is privately sent to the parties and to nobody else, then there's kind of an issue with the transparency of the process as well, because the entire purpose of the open court principle is to allow people to see justice in action. So if you have decisions that are never being released from the bench, and you don't know as an observer what the outcome was of what you just witnessed, and that outcome was just sent selectively and privately to the parties alone, there's another gap there. And I know that, in the scale of things with people waiting so long, that's probably not on the priority list, but it is an issue. So yeah, they do that so they can hear more in one day. They don't have to sit there and adjourn to draft this decision and then give it orally. But at the end of the day, there's still problems with that too. So they're working hard. You got to give them some credit. Like they've pulled up their socks since COVID, but there's lots of kinks that need to be ironed out for sure.
Now, Robert, you did bring up there, I think initially you're, sometimes the landlord and tenant are trying to negotiate a resolution, and it's kind of like this, how do you find that sort of happy medium especially when you're looking at a 7 month wait of, well, hey, if I go over to the board, I'm waiting 7 months anyways. And then, the tenant might be like, oh, you're filing an application against me. I'm just going to stop paying the rent altogether now. And, that ends up being a worse situation than trying to reach some kind of, hey, I'll give you an extra couple of days. And then at the same time, the opposite is once you kind of go that route, then, you're delaying yourself, because it's already 7 months, so you've just tacked on 2 more months of trying to get them to pay or whatever the issue might be.
Mm-hmm.
And it doesn't go anywhere because they're like, well, okay, in the end, I'm just not going to pay. And now you're out 2 more months. So how do you kind of, if you have, either, let's say probably landlord clients for the most part here, but it could be tenants on, maintenance issues, of where do you find that sort of happy medium of trying to deal with it, through negotiation before going on the board? Or is it just, file the application and then try to negotiate while you're waiting? Or any advice there for people in the landlord tenant sphere of how to kind of
Yeah.
handle those situations in light of the when, if this was happening 2 months later, you're like, okay, whatever, we file our application and in 60 days we'll get a result. But 7 months
Mm-hmm.
is a different story, especially as you said, these costs and mortgages and things are all piling up.
Yeah. Well, I mean, I think it's important to remember nobody really wins at the landlord tenant board. Not right now. From a legal representative standpoint, we have to set our clients' expectations from the outset. Like, we are going to do absolutely everything we can to get this to the board to prevent adjournments, any possible arguments that the tenant might make. You mentioned like kind of retaliatory. Well, I'm going to stop paying my rent because you decided to file this application against me. We prep our clients for the fact that once we pull the trigger on this, there could be retaliation. We'll deal with it if it comes up, but we always have to prep our clients to understand that. And we try to negotiate. So first of all, the application process starts day one because of the waits. Like, we don't have time to negotiate first and then decide to apply. What we can do is we can just get in line for a hearing, get our application before the board. That way the tenant knows that we're serious anyways. And then we actually have like we're in line. Who knows where the end of the line is, but at least we're in line. We have a bit of like a wall to push their back up to. Like, they're here, it's going to happen, at a hearing, it's going to happen. It might be 7 months away, but it could also be next week. You never know. And so when you have that kind of like that point where there's that line in the sand, like you, and then right from there. So we get that. We can always request to withdraw an application if we resolve it, or we can, the landlord tenant board, they just switched this a little bit, but they have something that, like, the concept of an advanced resolution request. So we can file our application and then resolve the application in an arrangement with the tenant. And so sometimes it depends on the circumstances, is very case specific, but sometimes that means cash for keys, like a compensation, like we put some money on the table and pay them to leave, and we would secure that with an N11 and then file it with the board, and then it's essentially an agreement to have them vacate the unit on a certain time, and then if they don't leave, then it becomes enforceable. The sheriff can come and kick them to the curb. But so it's a tough process. The negotiations also, like, if you have it's so case specific. So you can have plenty of situations too where the parties have different applications against each other. And so if you have an opportunity to maybe give them something that they want and get the landlord something that they want, or you can extend termination dates. Like, we're probably going to get a termination this day. Why don't you pick your termination date, and then we can maybe help you move. Like, there's all kinds of different ways. The sky's the limit, and it's very circumstantial. So, like, maybe the tenant has certain needs. Maybe maybe their problem is that they just can't find another place to live, and they need a reference letter from the landlord, and they need moving expenses. And like, if it means the eviction or the termination of the tenancy, I don't know many clients of mine that wouldn't provide that. So it's all circumstance dependent. And but yeah, the negotiations start as soon as we get in line for a hearing, we can't really budge on that. Like we've just got to get our clients in line, given the timelines at the landlord tenant board.
Yeah, and I guess I mean that's the sort of, it creates that there is a process. I mean, you kind of take the negotiations a little bit more differently, knowing that, hey, if this does get to the board and the next, it could be expedited, as you point out, in some cases, then that could be worse than whatever is being offered on the table. And maybe now I can come to the table in sort of ready to actually deal with it, rather than, well, can you go and file, or give me another week, and there's no incentive to sort of push the parties to the table to try to reach something.
Yeah, I
Now,
guess
yeah,
I guess on that same point too, I forgot to mention is that a lot of times too, landlords will have a certain right to make an application to the board based on certain conduct, but they don't really realize that that is actually a better way to get you before the board before whatever, like a rent arrears application. So say, like we'll have someone say like, yeah, my tenant hasn't paid rent for 3 months, and and yeah, so I want to bring a landlord tenant board application. Well, we'll canvass other issues with the tenancy. Well, like, when was the last time you did an inspection? Oh, I couldn't get into the unit, the tenant wouldn't let me do an inspection. Okay, well, have you like, are you responsible for like changing the furnace filters? Are you responsible for like maintaining the smoke detectors? And the answer is usually yes. So okay, well, if the tenant's not letting you in to do these crucial inspections, to do these fire safety related um, maintenance of your own property, then maybe will definitely put in the rent arrears application. But maybe that's a safety or a conduct issue that needs to be addressed on an expedited manner. Maybe we put out an N5 notice, and then we put in an L2 application for the board and request to shorten the hearing time to get us before the board on an even sooner basis than your rent arrears. You can have more than one situation going on at the same time. And so there's also that aspect. A lot of people just don't realize, like on the face of it, think like, oh, my tenant's not paying me rent, he's not letting me in there. My issue is that I'm out of rent, I'm paying his mortgage, but realistically, there's that issue in the background that actually might work to get you in before the board a little bit sooner and potentially get an eviction. If you're dealing with a residential tenancy, sometimes it's best. Sometimes you aren't going to collect your money anyways, even if we get an order for the sky and the moon and the stars. You have to enforce that. Like, how are you going to, you can't get blood from a stone. So sometimes just stopping the bleed, getting a tourniquet on it, getting the tenant out is the best solution. And if we can get you before the board, then there's other options than just going strictly with like a rent arrears application.
now let's maybe look on the tenant side. The other thing that I've noticed coming up is with rent control and these 2.5% increases, that sometimes the landlords kind of look at outside, well, let's call it outside the box ways of ending the tenancies, and in some cases against the RTA, right? Like, oh, my long lost son's coming back, and I'm going to put them up in this house, and then 6 days later you're like, hey, it's on Kijiji again. Now,
Perfect.
are you seeing
If that
things?
happens to you as a tenant, please call us. Please call us. Those are fantastic cases. I mean, they're not fantastic for the tenant that got evicted, but the consequences that now come with a bad faith eviction, especially putting an N12 or an N13 out there, and then not having the person who declared that they were going to move in, the consequences are huge. You can get, so like general compensation. We're not talking about moving expenses. We're not talking about your increased rate of rent wherever you had to move to because you were evicted. We're talking about general compensation. You take the last rate of rent that you were charged, and then you multiply that by 12, and that's what you claim for compensation, just for general compensation for having been the victim of a bad faith eviction. Like, and for a lot of people, like, rent is high right now, like $2,500. You're hitting the monetary jurisdiction of the landlord tenant board a lot of times with those cases. So yeah, like that, and that used to be a much bigger problem. But I'll tell you, like, when we have our landlord clients come in and say, like, I want to move my son into this property, well, we make sure that we go through, like, if this were a bad faith eviction, these are the kind of consequences that you could face. So and a lot of people don't know that, and a lot of people, there's a lot of information floating around from the pre change to the legislation. So a lot of people don't realize the consequences. And so, yeah, that happens. But that happens, and from the tenant side, it becomes a reverse onus too. So if you are evicted, the landlord says, "Oh, my son's going to go in there," and then the house is listed or the unit is posted for a re-rental. It becomes the landlord's obligation to prove that they didn't give the notice in bad faith. That's an easy case, and you're getting some that's probably the most that the landlord tenant board ever awards anybody are for these T5s, for the bad faith evictions. Um, so yeah, like, please call us for those. Be happy to take those cases. They're great. They're great for everybody involved. And you know what? It's nice to see once in a while people who do some slimy things get held accountable. So we are all about helping tenants out when that happens. So um yeah. I know a lot of legal representatives think the same way about those as well. Um because yeah, nobody likes, like, you're dealing with somebody who is and usually those cases they're no fault evictions, right? So you don't have anything like a rent arrears issue. You got people who are paying their rent, but maybe the landlord saw an opportunity and then took a legal means to try and capture a benefit of that opportunity, and they did so at the prejudice of the tenant, who had to then move their kids to a different school, and like, maybe they had to find a new job, maybe they had to take a 3 bedroom and now cram everybody into a 1 bedroom. Like, it's huge. You uproot people's lives, and so there's some pretty good consequences now for landlords who do that, and there should be there. That's the right thing to do, is take them to the cleaners if they're gonna act like that. So
And I guess related to that, you have then maybe the rent evictions, right? Where they're like, oh, I gotta do something on the property, and then you can't be in here while that's happening. And what happens again? Is it the same sort of concept if it's done in bad faith? Because again, part of the thing is once you're out, maybe you stomach the cost of if you're finding comparable housing, it's going to naturally cost you more. And you may not turn your mind to what was going on there, or you don't necessarily know what's going on there, like unless you have like a flashlight and you're up at the door, right? But
yeah.
uh compared to if it's being reposted a few months later, where you can maybe do a quick check online and you're like, hey, that's the address that I was living in, and it's up for re-rental, or it's being sold. What happens in those kinds of cases of sort
So
of bad faith rent evictions?
yeah, so it's the same thing. And I do want to caution that there were some legislative updates recently. I think probably the last couple months that I haven't reviewed yet. But like, with that caution in mind, my understanding is it's the exact same thing. It's a bad faith eviction if you are saying that you have work that's so extensive requiring a permit, and that the tenant has to move. Um, then yeah, like, it can be a no fault eviction. And then if they so a couple things. One is that there's a 2-year limitation period on discovering that whether or not it was a bad faith eviction. So that also applies to my son's moving in, the purchaser of the units moving in, my mom's moving in, that kind of thing. So you now have 2 years to keep looking back to see if during that 1 year period that there was supposed to have been a person moving in there, that they actually moved in. The other thing too with N13s, which is the rent evictions, is that you have the right of first refusal. So you can give the landlord notice in writing of your intention to move back into the unit once the repairs are done. So that's something that a lot of people don't realize, and so they look at after the fact, and they've moved, and then they realize, oh, they're re-renting it again. Well, I mean, technically, if they are re-renting it again, you didn't give your right of first refusal. Maybe they did the renovations to such an extent that were consistent with what they said that they were giving notice for, and that they've decided to re-rent it again. It's circumstance depending, but that's an option too. So
Yeah, I mean, and there's all sorts of I mean, with rent, I guess, I mean, in certain places, you have, like I said, you're limited to the guideline. I mean, there are obviously, maybe you can touch on where, the landlords are able to increase the rent beyond, I think it's 2.5% right now, but there are some of those situations. I don't know, how many of the above guideline increase sort of applications come your way. And then there's obviously the ones where there is no rent control, right? That, I mean, I don't know, in terms of, there's development everywhere now, right? But
yeah,
And when people don't realize that, hey, how
you're
come, JP, you told me 2.5%, and I was just told, it's another $300. I don't have my calculator in front of me, but that seems a lot more than 2.5% off my, $2,000 rent from the previous month, right? So maybe you
yeah.
kind of touch on that, because I know that that's, like I said, a lot of in the news where people are like going on strike, in Toronto, and they don't realize that, that they are entitled to go beyond that, for certain housing that's recently built, or firstly, rented out after, those changes came in place.
Yeah, so I just want to caution that that's not so in my firm, I don't do the above guideline rent increases. So I know that there is an application process where if a landlord wants to increase the rent above the guideline interest, I think, and again, don't quote me on it, but I think it's for things like capital expenditures or like significant renovations, something along those lines where they can apply to the board. And then like, I think an increase in municipal taxes is another ground for that. But yeah, there's an application process. There's also I think it's November 2018. Is it if there is like a new build after that date, after a date it's in the RTA, then I think it's November 2018. Don't quote me on that as well. I'd have to look it up. I don't have it in front of me, but if it's like a new build or if it was first occupied for residential purposes after November 2018, then rent control does not apply. I mean, I have my computer on me. I guess I could take a
Yeah, I'm
look.
pretty sure. I think that's the date there, but um, so what happened? I mean, is there like like a reasonable amount, or like, is there any recourse really if it's like a 2021 building, and you sign a 1-year lease, and then they're like, okay, well, now in year two you're going to be paying another 500 a month because demand is there.
So, yeah, like I mean, I guess you could run into that stuff. It's you still have to follow the conditions of the contract. So like it's still, I believe it still applies annually. Like you can't do more than one rent increase per year. So you still have those rent control aspects. I think it's just the like the cap that applies. I'd have to you're getting into some specifics that I would have to actually look up because I'm not really we're not doing too many of those. I can tell you what happens if you are subject to an illegal rent increase and you don't meet one of those rent control issues is that normally the tenant would just continue paying what their regular rate of rent is if it's not a lawful rent increase, and that can even happen in cases where a proper notice wasn't given. They didn't give the 90-day notice. It wasn't in writing, or the amount that was calculated was like 2.7% versus the 2.5%, something to that effect. The tenant would pay their regular rate of rent. The increase would then become what the landlord thinks is an arrears. They would take the case to the landlord tenant board, or if you're really stingy, because we're talking probably usually like in the amount of like under $20. So if you're really stingy about it, you'd say, oh, you didn't pay your rent in full this month, and you take them to the landlord tenant board, and then the board says, no, you didn't give your rent, and you didn't give proper notice of your rent increase, or no, this was an above guideline rent increase, you didn't get a permission of the board, and then they would deem the lawful rate of rent to be what it was before, and the landlord has to start again.
Yeah, I mean, and that also sort of speaks to the point of the importance of, initially you shared about, between self-representing usually and hiring a paralegal, because those little mistakes, especially when you have a 7-month wait to get to the board, and I'm like, oh, you made a mistake. See you in another 7 months, right?
Yeah, it's really
And
unforgiving. To be honest, for all of the quasi judicial tribunals, the landlord tenant board is very unforgiving. I mean, you can amend an application, but you cannot amend a notice. So, and the notice is what really commences the proceedings. That's the first thing you're giving them. That's like what you're giving to the tenant. This is the conduct you need to stop, or this is the amount of rent that you owe me. If you make a significant mistake on one of those notices, I saw a case get thrown out because the person put the unit address, like say for example, 123 Fake Street, St. Catharines, but they didn't put Ontario. And so can you imagine making such a simple mistake? You haven't gotten your rent. You get down the road to like 8 months in. you're representing yourself. You don't realize that's a mistake. Getting before an adjudicator after this huge wait, and then being told, yeah, sorry, the tenant didn't show up, but as an adjudicator, I'm going to look over your paperwork. You've made this mistake. Start again. And then you're starting again from the notice. You got to give a new notice out, that notice that's correct. You have to then file an application based on the termination date on the notice, which, you know, you give them another period of time to make the rent correction. And then you're going to landlord tenant board again. You're waiting, you're back in line, and then you finally have to get back to a hearing. And it's so unfortunate when people, and I mean, I get it. Like even as paralegals bridging the gap between self reps and lawyers, we're not cheap. Like we've got bills to pay too. So like it's not cheap. And I know that some people are just, you know, you don't get your rent, so you already have this shortage of income or ability to pay for a legal professional to help you, but they end up getting to the board, they do it themselves, they end up getting to the board, and then that's when they find out that they should have gotten a legal representative to actually to do it properly the first time. Because and we do hear people call us like the day that they got their order saying that they're or the day after their hearing saying, yeah, yesterday I was at the board and my notice was defective and I have to start again, can you just do this for me? And that's a lot of people who come to us. That happens to landlords. The reason that they're unforgiving is because they're dealing with the termination of someone's tenancy. So you're taking away someone's place to live. And so I guess reason, like, I mean, when you put it that way, I guess it's pretty important that they be very stringent. But for a quasi judicial tribunal, I don't think other tribunals are as technical with their paperwork proficiency as the landlord tenant board is.
And I guess that's interesting because, you know, when students sort of do their observations, and it doesn't necessarily always jive with the, you know, the nature of, you know, in the administration of justice, access to justice at the actual hearing, where, you know, they are maybe very forgiving on, you know, late, you know, here's the, you know, I just took these pictures yesterday and I never gave it to the other side.
Yeah.
So it's kind of interesting how you have that dynamic on some points that they're very technical, and then on others they're, you know, very more approachable about, you know, getting permission or adjourning a matter, whatever it may be. And so for a practitioner, it's important to understand, you know, these nuances of the adjudicator are just as important as, you know, whatever the RTA says in the legislation. And sometimes, you know, that skill is important to know. I mean, in other areas of law too, but, you know, in particular, when you're reconciling, how can they be strict on this, but not be
Yeah.
strict on this point?
Yeah. I mean, it's anybody's guess because, you know, like sometimes you think something's like pretty serious and then it'll get through. And then other times it'll be such a surprise that that an adjudicator took an issue with this particular flaw in a form or dispute as to the, as to like what the forum actually was saying. A lot of times you get the issues with N5 notices, which are conduct related issues where you have to explain what the conduct was. Those are like so technically specific, and you know, if you don't describe it properly, or you know, in some cases, if you don't have a date and time, they and the divisional court has stepped in to kind of loosen those rules. Thankfully, there was actually a case. Another legal representative put it on posted, I think, on one of the paralegal Facebook groups, but there was like a good divisional court case that came in and started softening the rules a bit. I think that the courts and the tribunals are starting to kind of realize what the issue is, and that, you know, it wouldn't be such a big deal if you got a hearing in 2 months and then your wait time was 4 months to have to start again. But we're talking like people waiting over a year to get before the landlord tenant board because they made a simple mistake in the paperwork. And it's a mistake that nobody's confused about. You know that your rental unit in St. Catharines is actually in St. Catharines, Ontario. So it's not like anybody's confused, but yeah, it's horrible. Like a lot of landlords are probably, I don't think that I would want to be a small time landlord at this point, until maybe the landlord tenant board gets back into a more efficient system, and they're getting there. But I certainly wouldn't be renting right now, and I feel for a lot of my clients that are in that situation.
Now, Robert, anything to add there for paralegal students that are interested? One of the this is one of the big areas of
Yeah,
practice. Anything
when I
from
was
that perspective there?
when I was in school, I hated landlord tenant. I hated it. I thought it was the most boring. Like because you're doing forms all day, and it was just like I was like, oh, I hate this area. I'm never gonna practice this. I don't know why I'm learning it. I like, I did the work, got through it, and then when I started my own practice, I was like, I took a little bit on. I was like, oh, okay, this is actually interesting. And then you come to realize like this is where people need help, and if you've got into this profession to help other people who need help, this is an area where people are frequently using this tribunal. It is technically proficient, so that means that by learning that skill set and by learning those small techniques to really master the filling out of these forms sometimes, or the arguing of this, what is eventually going to become a case in a hearing before the landlord tenant board, you're actually doing really meaningful work, and you are doing what our profession was born to do, and that is to help people who normally would self-represent themselves, or have to pay an arm and a leg for a lawyer. But you're helping them to navigate a very complicated tribunal, and there's a lot of people that need that service. And so, yeah, that landlord tenant board is now 50% of what I do. It like pays our bills. So you might not think it's like one of those sexy areas of law. It's not like provincial offenses. They're not making any courtroom dramas about landlord and tenant board proceedings, but um, that tribunal, like a lot of different areas that you might not realize are actually can be like quite lucrative if you're looking at it from a business standpoint. Like you're providing a service that people need, and there's a gap in the people providing it. So like, do I want to go to a big law firm who are either going to charge me a lot of money, or put someone who is like an articling student on the case? Or do I want to go to a paralegal who specifically does this every day and goes through the tribunal with other paralegals who do this every single day? So like you become like a part of that, the profession that provides that niche service to people who actually, and there's tons of people renting, there's tons of people who have rental properties. There's all these incentives to create new rental properties to make more affordable housing. So like it's not going anywhere. Residential tenancy law is not going anywhere. It's only going to be expanding larger. And so there's this huge market for competent legal service providers.
Now you did bring up that, and I think that's an interesting point. Is at the start you were saying, "Hey, I'm doing some professional misconduct work," and kind of feeding on that last point of, there's a lot of other areas that paralegals don't, especially when you learn about some of these tribunals, and you're like, uh, how come so many places have disciplinary, professions have these disciplinary bodies, and you may even have those experiences. You may have been working as a massage therapist before you took a Mohawk program or wherever, and you're like, hey, I know what you're supposed to do and what you're not supposed to do, and now I know how administrative law and I learned the rules of procedure, whatever got you into that area. So maybe you could tell us a little bit about some of the professional misconduct work you do, and how that's an area. I mean, a number of different areas, and again, learning different tribunals. You may have a couple of cases in this one, and a couple of cases in another tribunal, but the same sort of process that helps you, again, maybe supplement your landlord tenant work and your small claims work, that again paralegals are not thinking so much about as an area that they can practice in.
Yeah. Yeah. So there's like different reasons that I kind of like the regulatory discipline is like, so one is that your clients are all professionals. It's people who are part of like a professional body, and anybody who's going through the process to become a licensee with the Law Society knows like how difficult it is, how dedicated you have to be. You're doing an educational program which is accredited by a regulator. You're doing your exam, you're doing your good character assessment, you're doing all of these steps, paying all of these fees to get accepted into this regulatory body. And then you have these ongoing duties. So the people that you're dealing with who find themselves before the regulatory proceedings, a lot of times it's like, it's like the people that you go to work with every day. It's just you're dealing with professionals who maybe had like maybe they had like some technical non-compliance, maybe they made a mistake, maybe they had a knowledge gap that they need assistance with. And so I really like the clients in professional discipline proceeding cases. Um, when you're actually like representing in these proceedings, I think all of the different colleges or whatever the regulator, whatever the regulator it is, I think they all have their own like practice guidelines as to how they do and they're super flexible because they're not too common. Like they aren't happening every single day. Some regulators maybe, but a lot of regulators are not having hearings every single day. So even your administrative staff who are working at the hearing, they're pretty flexible. Like it's not very intimidating. You can, like you can perform more comfortably. Um, and so, I mean, not to say that there aren't technical and procedural considerations that you have to have, and you do have to read up on every single college or every single professional organization is different, and so that's kind of a bit of a challenging point, is that you have to kind of familiarize yourself. But if you know the SPPA, the Statutory Powers of Procedures Act, a lot of them they're very consistent with the basic fundamentals of those. And so, and you get a lot of like interesting cases, people who are like good people, go to work, they're professionals, they pay their bills. And when you're a legal service provider trying to, pay your own bills, it helps when your clients pay their bills too. So you're helping people protect their jobs, protect their standings in their professions. And that's very meaningful. A lot of people identify themselves based on around their profession, like you're a lawyer, I'm a paralegal, like I'm a business owner, like that's important to a lot of people. And so, and people work hard to get into their professions. And so, um, it's really meaningful to be able to sort of help people navigate within their own profession, but use my skill set as a legal representative to help them to navigate what is often a very stressful time for them. So I find that work is very meaningful, and it can be challenging. It's changing a lot. Um, Jordan Peterson right now is challenging the and I don't want to get too far into that, but like there's some court challenges that might change some of the scope that regulators have, or regulatory um, bodies have. And so like there's new emerging ideas that might come out of that. And so it's an area that, it's not stagnant, it's not trite law. Like there could be some neat changes that come out of this most recent court challenge. And so it's kind of interesting. It could be exciting. Who knows? It could change some things. It could, um, it could rebalance the power dynamic between professionals and their regulators. So yeah, it's kind of interesting. I'm just personally, maybe it's a personal thing that I'm personally interested in, but yeah, like I don't mind that. And what I like if you kind of just take a step back and look at it, like if you have your own practice, you can sort of just pick a couple areas that you are interested in and you have a personal interest in, and you can practice them. Like landlord tenant, small claims court, those really pay the bills. Those are our bread and butter. But I can use the same skill sets that I use advocating in a landlord tenant board proceeding or advocating before the small claims court, and I can apply them to areas that I might have a personal interest in. So regulatory discipline things, that's something I have a personal interest in. I like it. I like it as an individual, like having my identity heavily tied into what I do every day, like being a business owner, being in the business community, being a paralegal, being a legal representative. Like that's important to me. I can really empathize with other people who also are hardworking professionals, and so being able to use my skill set to do something I like and get paid for it, that's a good deal. So yeah.
Yeah, I mean that's certainly interesting. If it goes into the divisional court and beyond, because I know every time I'm teaching tribunals, I say, well, you have to realize that it's not just the individual tribunal, because any of these tribunals can have a case that goes out, to divisional court that you can indirectly say, well, hey, the law society, what about their authority in terms of what can their where's the four corners of where they can regulate, and then that goes
Yeah.
to the College of Physicians, it goes to the
And then
College of
every
Veterinarians.
regulated professional can just be impacted by their regulator maybe having their authorities clawed in, or maybe having their wider authorities solidified. Like there's plenty of changes that can happen, and the changes that happen in one appeal process can affect all kinds of different regulated professions, our own.
That's what, again, it's definitely an interesting area. And I think, yes, I mean, you got to find that balance because, you're not going to have, like 300 discipline matters that you're going to fall into your lap the same way where you may have, 300, landlords or tenant applications you're dealing with. So, it's something to keep in mind as, we certainly look at what can paralegals do. And there are like hundreds, or somebody went told me, I don't know, again, someone's ever gone and actually counted them all up, but I was told, there's like 1,000 of these, tribunals, across, the country that, again, in a lot of cases, paralegals have standing before. And, maybe looking at some of these areas as, your second or third area of practice, because as you said, once you kind of look at some of them and you understand the SPPA, a lot of them draw on those same principles. And some of it, again, is knowing the parties, right? That you're going to say those same administrative staff. And I know they like to have things done in this way, in this format. But other than that, I mean, I think, the general underpinnings of running a hearing as a representative, you can transfer from this college to another college, again, being cognizant of those individual rules, but the same kind of work, now you're dealing with a nurse instead of dealing with a veterinarian, or now you're dealing with a accountant instead of dealing with a paralegal. But again, the same kind of work you can piece together from a number of those different tribunals.
Yeah, I completely agree. It's like it's a whole different ball game. So yeah, it's interesting. I like it, and you just take those administrative law principles and you can apply them to whatever stadium you're going to play in.
Now, would you be missed if I maybe you could tell me a little bit about some of the small claims work you do? I mean, small claims in of itself, right? Like when people say, I practice in small claims, I mean that
Yeah.
could mean anything, right? So, what are
Yeah.
the types of small claims matters you do, and what's that like in terms of your practice?
Yeah, so that's a good point. Is like, I guess in terms of like defining the areas within the small claims court, a lot of it is contractor disputes. So defective workmanship claims on either side, whether we're defending a contractor, whether we are, um, doing unpaid invoices based on like claims of set off for defective workmanship on the part of the contractor, or like the client isn't happy with their work and they have to get somebody else to come in and repair all these deficiencies that were in breach of an agreement. So like especially after the summer or during the summer, that's our firm gets inundated with these contractor disputes. That's a lot of like concrete driveways, pools, a lot of the outdoor work, and then but then interior stuff too, like you're dealing with like renovations and construction projects, so that's a big area of small claims. Another area of small claims completely different are wrongful dismissal cases, so employees who have been terminated or who have been constructively dismissed and then were not provided their proper severance. So your severance entitlements, if you're working in a job non-unionized and then your employment is terminated, whether or not it's with, well, a lot of employers will say that the termination is for cause. The threshold to meet that for cause termination is very high. So a lot of times it wouldn't meet the reason for the termination wouldn't meet that for cause threshold. And what a lot of employees don't know is that when they are terminated without cause, which is most terminations, they're entitled to severance pay um, in lieu of the notice period that they would have gotten. And so the Employment Standards Act sets like a criteria, but that is like the bare minimum of what you are entitled by statute to get. And so what we take to the court are your common law entitlements, which greatly exceed what the minimums under this Employment Standards Act are. And a lot of times an employer will terminate somebody, they'll say, we're just going to part ways. Here's your mandatory statutory minimum amount under the Employment Standards Act. You work 2 years here, here's 2 weeks pay. It's very different than, a lot of people don't realize that. So that's where we come in and we let people know what their actual entitlements are approximated to be based on what your students are probably learning in their employment law classes, Bardell factors, and then other specific factors that are unique to the individual. um, they're usually entitled to way more than that. And so, where we come in the small claims court realm, are that if you're working part time, if you're not making significant amount of money, if your notice period is not as high, like there's a thriving area of employment law, but a lot of times your severance entitlements will fall under or very close to the $35,000 monetary jurisdiction. So we take a lot of those employment law cases, your regular retail employees or um, restaurant employees. Like there are a lot of professions that can actually use a paralegal to take their wrongful dismissal case to the small claims court rather than go with an employment lawyer to the superior court. So we do that. We do some personal injury where the damages are within the monetary jurisdiction of the small claims court, 35,000. Yeah, like contract disputes, just like basic contract differences, and that could be like people get into contracts with all kinds of different issues. Yeah, that's probably the bulk are construction related contractor disputes and then employment law situations.
Yeah, again, like I said, with small claims, like there's so much that it's in of itself. It's like an avenue for all of these different areas of law. And again, whether it's employment law, whether it's contract law that you can kind of draw upon and in the venue of small claims court. So when someone says, "Hey, I really want to do a small claims court," I mean that could mean anything. So something
Yeah.
for any of the students that are listening is that you can find areas within small claims that you can sort of focus your time around. So Robert, I mean, we're kind of reaching, I know we had a nice talk even before the cameras started
Time flies
rolling,
when
so
you're
to
having
speak.
fun. So.
Yeah. So any final words of wisdom for any of the students, any newly licensed people listening, and certainly congratulations on all the success there, as you were telling us, from that little tiny office in Thorold to, winning Reader's Choice Awards, in Niagara, having 3 offices, 5 licensees there. So any final words of wisdom as people, I mean, again, I think, 4 or 5 years ago, you were sitting in a physical classroom, right? I mean, just before the pandemic, and here you are. And I think a lot of times, I certainly love bringing in paralegals that are not 15 years down the road, because it's a lot easier, I think, for students listening to say, hey, in 2028, this could be me, and you can see real actual examples of these phenomenal paralegals like yourself that have gone from that seat in the classroom to coming here and talking to students and newly licensed people, saying, look at the success I've achieved. And sometimes it's like tooting your horn. I think you said it yourself there, right? That hey, you don't
Yeah.
need to, you can be proud of your accomplishment. So I mean, any final words of wisdom? And thanks so much again, Robert, for joining us.
Yeah, just a couple of things. Like I would say a lot of people kind of going through to be a paralegal wanted to be a lawyer. And I would really point out the fact that we have carved out our own profession and we are unique, and we operate in the same way that a lawyer would, but we fulfill a very important area of the legal services market. We bridge that gap between people who are completely confused and representing themselves, trying to navigate this complex landscape of different tribunals and different court processes that are very complicated and technical in many cases. And we are giving them the opportunity to access justice. And that can materialize in so many different ways. But, most people don't have the money to go and put down a retainer for a fancy lawyer. And so if we can come into the market and provide people this alternative option, that is something to be really proud of. So I'm very proud to be a paralegal. It's something that you shouldn't be embarrassed to say I'm a paralegal. A lot of people don't know what a paralegal is because outside of Ontario, there isn't really much regulation. There isn't the creation of our profession that regulation has brought us here in Ontario. But yeah, like it's something to be absolutely proud about. Like being a paralegal is an important job. You do important work, and you get to make a meaningful difference. And when you finish your day and you look back at all the different files that you touched and all the different progress you made on some of the most stressful things that people are going through, It feels so good. It's an addictive feeling to be able to like chase those meaningful and rewarding benefits of doing what we do every single day. So that's one thing, is like, be proud to be a paralegal. You're in the right course. You're you're going into a profession that has so much need. There are no shortage of people who need legal services and who don't want to pay a lawyer and don't want to do it themselves. That's where we come in. And so you're entering a market where the sky is the absolute limit. And look, you might graduate school and then apply for a couple of jobs and be like, oh, this is tough. I can't get a job right now because I don't have the experience. And then like, everyone wants experienced people. How am I supposed to get that experience if I can't get a job out of school? If you aren't getting the opportunities to do what you want to do, just do it yourself. Just take the plunge. Start a sole prop if it's the easiest way to get it done. Put your back up against that wall. Go get a small. I started with a $5,000 personal line of credit to get my business under wraps, and I started taking cases. You don't have to take every case that comes in the door. Don't take anything that's too complicated, but take cases that are within your zone of proximal development. Take those cases that are a little bit more complicated than what you think you can manage based on your education. Have a good mentor to draw on and to be able to call up and ask questions to, and then just get out there and kick ass. And then and that just becomes addictive. And then people radiate towards other people, to people who are passionate about what they do. And if you're passionate about what you do, if you're dedicated towards helping people in the way that we do as paralegals, your business or your endeavors will pay off. People will flock to you and you will be successful. So if people won't give you that opportunity, don't be upset about it. Just go and make your own opportunities. The world is your, what do they say? The world is your oyster, or something weird like that. Just, get out there, do what you got to do to make it happen, and make your own opportunities. Be your own boss if nobody will be your boss.
Perfect. So thanks so much once again for taking the time and joining us, and thanks for everyone for tuning in.